the court sums it up here. Whether the allegations state a plausible claim for actual damages is different from whether the federal court has jurisdiction to hear the case. And so if you're deciding whether or not the plaintiff has actually pled actual damages, that's the merits. And this is not the proper way to get to those merits. Now, if you look in the footnotes, you'll see the court kind of dodged a couple of issues here because it wasn't necessary. And courts are really supposed to only decide the issues that are necessary rather than kind of going down a rabbit trail and saying, well, we want to give you some advice on this. And so this was proper for the court to not reach this issue. But one thing the court chose not to reach is the argument, hey, my claims are not moot because you did not offer proper attorney's fees. And the case law, I think, is very clear on that made it a defective offer. And then the court in the second footnote says, look, you can still attack the merits of the case. You just have to do it in the proper way at the proper time. And you did not do that. And here's what the court ends with. What Progressive cannot do is what it attempts to do here. Get rid of all the claims by offering to settle only those claims it deems legitimate. And we see this all the time where debt collectors, they come in to lawsuits that are filed. They say, well, look, we have decided that half of your claims are not valid, so we're not going to give you information on those, or we don't have to deal with those. And we always have to remind them, okay, debt collector or defense lawyer, remember, you're not wearing black robes. You don't get to make that decision. The judge makes that decision, or the jury makes that decision. And we see this also with defendants. They'll come in and they'll offer $2,000, $10,000 for actual damages. And they say, well, there's no way you could ever get more than that. And we kind of scratch our heads, go, well, wow, that's impressive that you know what a jury will do, and we don't even have a jury here. How do you know what my damages will be? And so we point out verdicts that we have received, judgments that we've received in these types of cases for six figures. And the defendants hate that, but that's just the reality of it. So they're trying to use these offers of judgment in a way that they really weren't designed to be used. And it's good to see opinions like this one that say, no, you can't do that. Do things the right way and the right time, but don't try to get too cute here. Or we've even settled cases after a jury verdict has been entered in our favor. So the point is, we're always talking about settlement, always reaching out to the other side. Are you interested? Now, they don't have to settle. There's no requirement that they do that. But if they do not settle and they are not reasonable in trying to settle with us, then again, there may be consequences, and we can talk about that in your particular situation.
Malice by the defendant or defendants. What is malice? Malice is an intent to cause injury. This is malicious, okay? This is somebody who's just being malicious. As it says here, despicable acts of a defendant. What is despicable? Things that are despised by reasonable people. What's a reasonable person? Tell it to the jury. Hopefully they agree with you. So despicable acts of a defendant, despised by reasonable people, and malice, willing and knowing disregard of the rights or safety of another. So despicable acts, knowing and willful disregards of the rights or the safety of another. Okay, so lots of things can be malicious. Things that are extreme and outrageous, things where you just go, holy cow, who would do that to another person? That's malicious. That's what you're looking for. Now, the final way, number 3 here, actually it's number 2 on my chart, but is oppression. Oppression, what is that? It's, again, despicable conduct of a defendant which causes cruel and unjust hardship in knowing disregard of the rights of others. So that may seem similar to malice.